if the enforcement agent applies to the court, it may issue a warrant which authorises him to use, if necessary, reasonable force to enter the premises or to do anything for which entry is authorised. Apparently, although nobody ever saw it, there was a warrant, but that appears to be saying, even though a possession warrant may have been in existence, they apply to the court, which may issue a separate warrant which authorises him to use, if necessary, reasonable force, blah, blah, blah. To clarify my opinion of this legislation, Section 21, Part 2. If the enforcement agent applies to the court, it may include in the warrant provision authorising him to use, if necessary, reasonable force to enter the premises or to do anything for which entry is authorised. So, they can either have a separate warrant under Section 20, or the court may put provision in the possession warrant, Section 21. Section 26, the bit which I was trying to mainly get to read. The enforcement agent must, on request, show the debtor and any person who appears to him to be in charge of the premises evidence of A, his identity, B, his authority to enter the premises. The authority to enter the premises is the warrant. Did any of my 1 million witnesses see a warrant? Me neither. Right, to move on, various other things unimportant in this part. This is a copy kindly borrowed off the internet. I haven't been furnished with my copy, unfortunately. This is a document printed on behalf of the HM Courts and Tribunals Service, named an EX96. Now, this document, you can have a look at them on the internet because I'm not reading it all. But basically, as we've seen, there's no authority to use force. So, the person entitled in this case, apparently, the lender, signs this form and sends it off to the bailiff. There is a time on you somewhere where it's got to be set. 3 working days before the appointment. Otherwise, the appointment will be cancelled. So the person in charge, or authorised rather, signs this to authorise force. Now, let's look at that in context. The police, only under certain conditions, are allowed to use force against us. The judge, it would appear, apparently doesn't authorise force in the warrant. Your next door neighbour or your friend cannot use force upon you unless it has specific conditions which allow it in law. Self-defence, and even that is tight. So let's turn over to the guidance notes for the EX96, printed on behalf of HM Courts and Tribunals Service, just to clarify what I'm saying. Top point. The entitlement to use force comes from the authority given by the person entitled to possession. Joe Blogg's on the other side, some spotty 24-year-old sat behind a computer. And not by virtue of the issue of the warrant of possession. Not by virtue of the issue of the warrant of possession. Next point. They are not empowered to instruct or order the bailiffs to use such force, reasonable or otherwise. Now, hands up, million witnesses. Who believes that that was reasonable force? How many locksmiths go with a sledgehammer, a crowbar, and an angle grinder? Bullshit. They just stick a couple of pins in the lock and it's open in 3 seconds. That's it. Thank you so much for all your support. Beautiful community. You're just the support. There is hope. there is hope. There's still community left. We'll help each other. Thank you very much.